Please take the floor and feel free to introduce yourself.
Thank you very much, Mireille. I can't really see myself or hear myself here, so I hope that everything is going okay and that you can hear me. My name is Anne Teo. I'm a PhD student at the University of Copenhagen, Faculty of Law, and today my paper presentation is entitled The Unbearable Likeness of Being, the Challenge of AI Towards the Individualist Orientation of International Human Rights Law. Now, a basic overview is that this is a conceptual paper, meaning that I will not focus on specific discrete rights. So specifically, I examine how the international human rights law framework is oriented around protection of the individual and how AI machine learning systems afford a form of structural atomization of the individual in ways in which the human rights framework is ill-equipped to respond towards. So this paper sort of provides a high-level overview of law as a normative enterprise. And in terms of terminology, I will use the terms AI and machine learning here interchangeably, focusing on many aspects of this paper and challenges posed by machine learning. And I use the term human rights here to mean the international human rights framework that was put in place in the mid-20th century after the Second World War. So this is how I will proceed. First, I will introduce the two premises of this paper that I take as starting points for my claims. And then I make the claim of the structural atomization of the individual in three ways. And then finally, a short recap. Due to the limited time, I might not be able to explore the solution space in the paper, but let's see about that. So the first premise is that human rights is typically understood as an individualistic concern. At least that's how it's been theorized, and it's associated with the idea of this Western liberal autonomous individual, fashioned through theories typically associated with history of human rights, right, found within human rights textbooks. So the individual as standing alone as a sovereign master over his or her own life. The subject of concern within human rights law is the individual. But it's an individual that has the image of standing alone and not specifically in relation with others. In distinction, I argue that the sociality aspect is an important but neglected element in the ontology of human rights, namely that the individual, that is the subject of rights, is not a free-floating individual in the world, but one that is embedded within social context that she or him find herself in. This is found, amongst others, in the theory of put forth by Carol Gould, who provides that human rights are fundamentally social or relational conceptions. We can also see this thinking reflected in, for example, the UDHR, the Universal Declaration of Human Rights, through specific rights, but also in the preamble. The preamble, which is the top part of the declaration, which basically provides a sort of vision and purpose of the document. So the preamble talks about the human family. Article 1 talks about acting in a spirit of brotherhood, and other rights, sort of, for example, the right to privacy, also talks about relationship with others, and so on and so forth. We also find elements of sociality reflected within economic, social, and cultural rights as well. So a purposive interpretation of these sets of rights actually pertain to individuals in relation with others in communities. And that's my first premise. So the second premise actually challenges this normative equivalency paradigm that has been assumed by human rights lawyers, human rights practitioners, when it comes to dealing with new challenges, including from technology. This is the paradigm that we are familiar with and which is named in many human rights documents, namely the fact that, you know, the rights offline are the same as rights online and that they apply as well. They are normatively equivalent, so to speak. So policymakers and human rights practice proceed from this normative equivalency paradigm. However, This paper challenges this and highlights a tension, namely that one key element of the human rights conceptual framework, the individualist framing of rights protection, namely that rights are oriented around protection of the individual, is being challenged. And these challenges go beyond the first order discrete rights, so your freedom of expression, your right to life, freedom from torture, etc., and raises second order challenges, second order concerns that are foundational in nature. And this will come in a bit. The claim, the master claim, the overall claim that I'm making is that the individual is being structurally atomized through the affordances of AI ML systems. And for the high level introduction in this particular slide, I can say now that the structural atomization occurs in three ways. I will go into each of them in a bit. So first, the instrumental atomization of the individual, the instrumentalization through optimization, and finally, the contextual atomization of the individual. So the individual, as we know it, stood at the front and center of human rights law, the central subject of concern. And this was shaped by the exigencies of the Second World War, right? Rights revolved around the individual. And this is reflected in the vocabulary of the rights themselves, but also the fact that you have to prove some kind of harm to the individual in order to forward a human rights claim of a violation. What I'm not saying in this paper is that the impact of AI affects individual human rights that has been examined by many scholars. I'm also not saying that AI, the effects of AI goes beyond the individual to affect the collective or society. That has also been looked at by other people in much better ways than I can do. But what I'm saying is that the individual is being structurally atomized, othered within the context of the human rights framework in ways that ironically leaves intact individual rights of the framework itself. I will unpeel this onion in a bit. So it's a trite observation now that actionable insights can be derived from data-driven AI systems. And in order to apprehend users as individuals, these data-driven systems assemble them into groups based on likeness and with other individuals. These groups are fluid and widespread, and who's part of a group and who's not can change all the time. The individual can be grouped in ways in which she might disagree with, in a process in which she has no say. So the deployment of AI systems within areas tightly bound with moral considerations of autonomy should actually give pause, because it displaces the very subject that it seeks to know. So the subject is actually not being read, but also being made in a way. And we also see this reflected in some of the discourse, the scholarship around migration law and refugee law as well, how data-driven systems work there to make individuals. Contrast this with the notion of respect for autonomy, read through Article 8 of the European Convention of Human Rights, which entails that the individual should actually have a say, right? This notion of self-governance, arguably also in terms of how she is read and modulated, because it consists of the meaningful exercise of autonomy. One example I give here is in terms of emotion recognition, where an individual's muscle movements, facial movements are said to indicate things like employability and criminality, these values imputed to a face or muscles. We can also think here of gait detection, for example, where your walking gait means that you're being read as a suspicious person on the one hand, or potential terrorist suspect, even though you're just doing a daily activity. Now, what harm does this do? We could raise, privacy concerns, GDPR concerns, but they're not so straightforward, right? You need knowledge, you need to know something is happening to you in order to challenge the fact of being read in this particular manner, or if you're being read wrongly. But also you might not be personally impacted. The concern is one of a larger nature, societal nature. Instead, I say that the harm is of a foundational or structural concern, wherein through this othering of the individual, through instrumental atomization, the individual is also less able to raise a claim of deviation of right standards because she has actually no one to compare her experiences with. Her social context has been abstracted from her. My second claim is two-pronged. The instrumentalization through optimization claim is two-pronged. First, I look into the fact that individuals are instrumentalized through optimization parameters within AI systems. And then if this is the concern, I go one level up and see if actually human rights can be optimized in order to counter the instrumentalization of the individual. So first things first, the underlying purpose of the design and deployment of AI systems revolve around optimization of a given goal or performance metric, right? And the process of optimization involves a certain level of abstraction, abstracting away unnecessary noise in relation to the tasks at hand, and utilizing data that is both considered relevant and computationally tractable. Now, in rendering the individual computationally tractable for purposes of optimization, this also compacts incommensurable values into computational optimizations. And I use the example of Vrije in the paper, which is a traditional statistical model used to predict the likelihood of recurrence of violence against women in the household used in Spain, whereby one of the parameters that was used was the number of children in a household was used as a potential, it was used as an indicator on potential risk of violence. So on the one hand, predicting violence is hard to compute. So, but available data is available. But what you are actually using the data for and what you are actually optimizing it for are two different things. And for the Dutch case, the Siri case, I think we're all familiar with that case by now. The algorithm measured fraud suspicion through supposedly very innocuous acts such as missing medical appointments or water level usage, because that is the data that is computable and optimizable. Both examples reduce measurability of risk, trust, entitlement through computational legibility instead of putting the individuals affected at the front and center. And in dealing with this, a lot of scholarship has also revolved around fairness of AI systems and fair data representation. But there are also internal tensions within that discipline. So, for example, the fact that two different types of fairness cannot be easily compatible with each other. So can we then go one level up? Can human rights then be part of the optimization process itself? Well, we can say that sort of, yes, because human rights is in a sense a process of optimization, whereby many rights are not absolute rights. What is needed is a process of optimization. Rights are balanced against each other, and the most optimal account wins, right? Determined in a court of law. But states can also, of course, take measures to protect public health, public safety, and so on. And during COVID, we saw rights being limited in different ways. But unlike AI systems, it's difficult for human rights to scale. Human rights cannot scale properly in this manner because it's individually determined. It's individualistic. It goes on a case-to-case basis based upon contextualized considerations. And these considerations can change over time. So, for example, the Rabat Plan of Action on Incitement and Hate Speech looks into how to determine whether or not a speech is hate speech by looking at 6 different factors. So, for example, the identity of the speaker matters, the reach of the speech, the medium of the speech, the intent of the speaker, etc., etc. These are not actually easily computable, but are to be determined on a case-to-case basis. Another aspect is that platforms, so for example, your social media platforms that want to regulate this has a legitimacy problem. We've also heard prior speakers talking about this. States have the legitimacy and accountability mechanisms in place to ensure that measures can be challenged, but the legitimacy aspect is missing in relation to private companies doing this. Machine optimization is also about acceptable error rates, right? So essentially, it's ontologically different sites of concern, whereas the premise of human rights is from those error rates themselves. So you can say that these are arguably fundamentally incompatible premises, at least in the current iteration of the human rights framework that we have. The design of human rights responds to the language of violations towards the individual, less well to conditions of subterfuge, of othering and obfuscation afforded by such systems. The third claim is that the individual can be othered through contextual atomization, so through AI systems, mediated shaping of epistemic and enabling conditions, which I claim can threaten the condition antecedent for socially situated exercise of moral agency and with it, human rights. The concern here is that the individual is being othered from her interests, and if these conditions, the epistemic and enabling conditions, are being shaped for you, then it affects your exercise of moral agency, your autonomy. Now, of course, you can say that humans are mediated in their environments anyway, by others, by society, and so on, but the distinguishing factor is that with these forms of mediations, the conditions of perceivability, knowability, and avoidability are present in varying degrees. Whereas we can argue that perhaps all three are under pressure with AI systems. Deepfakes is perhaps the most obvious example, but my claim here is not about absolutes, right? It's not about truth or falsity, whether or not people believe deepfakes, but the precarity that it introduces to epistemic conditions. And this contextual precarity can also be traced to, for example, online choice architectures, or personalized choice architectures is a case of sort of not knowing what we don't know. The content modulation and algorithmic amplification introduces precarity into epistemic conditions. Now here, I'm not talking about epistemic bubbles or echo chambers, or whether or not this leads to political polarization and so on, because the literature on that is actually split. But what I'm talking about is that the wrong lies in the precarious background conditions through a splintering of a common context for the exercise of moral agency within the social settings that the individual finds herself in. And this leads to the individual being atomized from a socially situated context. What is considered as a shared social space is up for grabs. And it is this element of...
Hello?
Yes.
You can now hear me. So you have gone past the 15 minutes. Can you perhaps wrap up?
I will wrap up right now.
Thank you.
So I was actually going to the end. So the individual is central within international human rights law, both in terms of the vernacular of rights itself, as well as the claiming of rights and remedies. But one important point to remember is that human rights is not a wall that stands still. Yes, there can be new rights in response to new challenges, but sometimes challenges also necessitate a re-examining of the foundational assumptions that hold up the whole international human rights law edifice. So while the individual is central to human rights law, the individual can be atomized, optimized in structural contexts that relate in important ways to how the individual exists and functions in society, but in which human rights law is currently inadequate to respond. Thank you.
Thank you. Yes. So now the floor is for the replier. That's Reuben Binns. We always start with silence.
Hi, can you hear me all right?
Yes.
Perfect. Okay. Thank you very much for producing such an interesting paper, Siran. It's really a good read and stirred up a lot of interesting thoughts for me, which I'm just going to rattle through. I don't have a very structured response, but it's a series of interesting thoughts that reading the paper sparked in me. So I'll start with something that I quite appreciated about this paper was the language of atomization. I think is a more productive way of getting at the problems with AI than some of the previous language that's been used, I think, to try and articulate some of the concerns you've articulated. So, for instance, notions of group privacy, or the idea that AI is creating new groups of people, or putting individuals into new groups that previously didn't exist, that have been generated by an algorithm. And that's been the language that we've seen in the past around group privacy and so on. And I think I find the language of atomization and the way you describe atomization as a more useful way of getting at these problems, because what these AI systems typically do is not to place people within groups, but rather it's to place individuals in large, complicated feature spaces. So it's putting an individual as a point in a map that is the map is very difficult to understand, rather than putting people in a group where arguably they might be able to say, oh no, I don't believe I belong in this group, I belong in that group over there. Actually, what these systems are doing is creating very large and complicated maps in which people are represented as individual dots in those spaces. And I think the language of atomization, as you describe it here, better captures that reality. Which leads me on to a related point, which is, I think you mention in various points that the way that these systems represent individuals is also not fixed. So in the same way that I think grouping is a misleading way of thinking about it, the idea that we're fixing people in space is also not necessarily an accurate portrayal. And so you note that while in some places you say that it's problematic because it fixes a snapshot of individuals, I think actually in other parts of the paper you get across very well that these things are always fluid and changing. So depending on the training data, depending on the specific hyperparameters, you might end up with an AI model that puts people into a different portion of the feature space than they were in before. And so you mentioned Van der Sloot talking about the fact that groups are fluid, and where you're placed from day to day might be very different. There's also Niels van Dijk's paper where he talks about the Deleuzian term individual, which indicates that there's this endlessly divisible and endlessly changing range of data representations. And I think that's a very useful and important aspect of this that makes these technologies particularly problematic. Also, as well as being fluid, so the systems are representing people in different ways at different times, they're also brittle in the way that small changes can result in big differences in how people are categorized. So all of that leads me on to a different bit of the discussion where you talk about one of the problems here is that people are unable to anticipate how they're going to be represented by the system, unable to influence it in any way, unable to argue about the way that they're being represented and to have some sort of influence over how they're represented. And I think that's another very important aspect here. So the idea of human rights as operating in a space where human beings have the ability to organically negotiate how their social relations are structured and how they're represented by others. And I think you can maybe it's useful to consider a few examples and contrasts here. So one being, the contrast between social categories that get invented, which have some basis in reality, but that are created over time. So Ian Hacking talks about categories like autism or obesity. These are medical categories that get invented through social and scientific processes with some basis in reality, but with also a heavy sort of socially constructed element to them. And we can imagine in those kinds of those forms of representation and structuring, people have the ability to claim or not claim those categorizations, and the ability to try and reclaim them in ways that enable them to figure out ways to get medical treatment if it's in the cases I just mentioned, but also to change the perceptions of what it means to be in those categories. And I think what I took from your paper is that that's one of the problems with AI systems, is that it's much more difficult to imagine how people will go about having a say in that sense. So that was something I found quite useful. I thought the discussion of optimization was very interesting in relation to the sort of utilitarian approach and how that rubs up against traditional individualistic conceptions of human rights. So the point was very well made that we can imagine, we can point to examples where human rights does engage in a kind of utilitarian optimization, in the sense that if we're deciding whether something is necessary and proportionate, we might need to sort of engage in counting of harms and magnify and measuring the size of various harms and weighing them up against each other and coming to a conclusion at the end of that whether a certain infringement of rights is justified on the basis that it does less harm than the rights that it's protecting. And so there is this kind of utilitarian balancing built into human rights law. And I think that's an interesting point. And I felt like the response to that was that you made, which was that, yes, sometimes human rights does involve these kinds of trade-offs, but there's a lack of legitimacy when it's done by an ML model. I wondered, because the response was partly to do with the fact that when a democratic state does that kind of balancing process, it has legitimacy because it's a legitimate democratic state. But that begged the question, what if it's a democratic state that's deploying an ML system and they go through a process of balancing up rights and they come to the conclusion that actually this particular balance between false positives and false negatives is justified. We know that if we deploy this system for this purpose, we're going to end up with such and such number of people falsely accused or falsely incarcerated, but that's legitimate because we're balancing it up against another type of error. And that begged the question, is the problem just that ML is being deployed by actors that don't have that legitimacy? So that's maybe something to consider further. How am I doing for time? I've got a few more points, but I don't want to run over too much.
I think you're about towards the end, so okay. The software now overrules you for me. Can you see that? Yep.
Okay, so I'll wrap up there to say that, just to end on one final point, is AI necessarily atomizing, or is it something to do with the logic of AI as it's currently deployed, and the specific types of technologies and the specific ways in which it's deployed to control populations? And can we imagine other forms of AI that would be targeted at different actors, maybe targeted up towards where power is coming from, that might escape some of these critiques? So that's my final thought to end on.
Thank you very much. So Anne, would you want to respond to this first before we go to the questions?
Can you hear me?
Yes, perfect.
Thanks, Reuben, for the feedback and for the suggestions as well to look into different aspects, the point of group privacy and social categories that you mentioned, especially. In terms of the way I framed the issue, it was also in response to the many different literature and scholarship available that already looks into this problem from a human rights angle, or they look at it from a human dignity angle or an agency angle. And I feel that, the human rights aspect of things has not been fully unpacked, especially in terms of some of the foundational assumptions that underpin the framework. So that's why sort of I took this particular way of looking at things. And your point about how within group privacy, whether or not the different notions of group privacy that has been forwarded by van der Sloot as well as Mantelero, whether or not it captures the different aspects of the problem. And I agree with you that it doesn't, because the notion of a group there assumes or needs to assume some form of social saliency, which also goes to the other point about social categories that you made. And social saliency needs to exist both in sort of objective forms and subjective forms. People can claim as to whether or not they belong in those groups. And that's this aspect is also missing within AI systems. In relation to your point about optimization and where I talked about, the fact that states have legitimacy in order to undertake this human rights optimization process. Well, yes, in a way, but also states are also constrained by other reasons. For example, rule of law reasons, where people have to be given reasons. There needs to be certain aspects of transparency involved. And people need to know the laws or rules that they are subjected to in advance. So there's also other constraining factors there, even if the state were to use AI systems as optimization tool. Is your final point about whether AI is actually optimizing or whether or not it's actually the logics that's involved in relation to the systems that we have today? Yeah, it could very well be. I'm not so much of a technical expert in that area, but I think also there's also been a lot of scholarship in terms of using AI to target the powers that be, right? Where power is coming from. And yes, I think that is also definitely another possible angle to look into, although the question of resources and distribution of power is another challenge to go through.
Thank you.
Much. This was a very rich paper, a rich presentation, a rich reply. Questions? To make the discussion even more rich or focused, whatever you like. That means I'm going to, in the meantime, while you're making up your mind what question to ask, looking at the chat, which is applause. But I think that's for something else. It's about whether we can hear things. Sorry. Trying to simulate a conference coffee break. That's fantastic. Yeah. Now I can also not properly see whether the comments that I'm looking at are for which paper. I'm going to the final questions. Yeah, no, they're not really. José Antonio Magalaus is thinking of Deleuzian individuals also, but that's not really a question, I think. Individuals, sorry. Okay, if nobody has a question, yes, Giovanni. Or a comment.
I've seen it's more than a question related to this content, it's related, let's say, so it's a little bit to start a discussion about that. Even if I'm not a legal scholar, I hear a lot of what is happening in the legal discussion. So what I notice in the area of Amsterdam, there is a lot going on. I heard about personalized law. So that's a kind of interesting phenomenon in a way, because here you're fighting against the personalization that is made by algorithmic machine learning type of algorithms. But on the other end, there is a debate whether there should be some form of, let's say, profiling in order to design better laws. So there looks to be a tension in general with respect to management of the flow of any type of regulatory purposes towards trying to aggregate in people into some kind of profile. On the other hand, there is the need, as you're saying as well, that, I mean, there are you are noticing that the individual need is also about not saying explicitly that you don't want to be classified within that group, with that within that category. So, in essence, what I'm saying is there is this tension. So, from the perspective of technology, not to be grouped by what technology is enforcing you to be, but then what are the discussion with respect to what is happening with respect to this idea of personalized law? If you're aware of this debate.
And are you aware of the debate about personalization of law? So it's legal singularity. If you can map human behavior and at the same time everything that that particular agent is interacting with, then you could, instead of apply a general rule, you could apply a rule that is completely customized, personalized to that particular person. And some people think that's the ideal situation. Do you see connections with your concept of atomization, what AI does, with the way some people understand human rights as kind of atomized, rights of atomized individuals? Are you aware of the discussion?
To an extent. I'm definitely not an expert in it. Human rights law is more my area. I think sort of at a high level, a personalized law might raise certain issues of perhaps fairness, as well as challenging this sort of foundational conception of what law is. It's almost, in a way, optimization on opioids, I would say. So it kind of actually adds to the 3 points that I made before. So you can probably hear that I'm not for that particular personalized law, because also I take law as being informed by the social context that we live in, and that it's constructive and it's constitutive in that particular manner. And how much of personalized law would take away from that, I don't know, but I think quite a lot. But having said that, I have to qualify that I'm no expert in that area.
Okay, thank you very much. Are there any more questions? Yes, Paulus, please.
Hello, this is Paulus again, Radboud University Nijmegen. I don't have really a question, but more of a comment. I really liked of your paper that it brought up the subject of optimization again, which you of course also have seen in the privacy literature from Seda Gurses in her POTS paper and stuff, where she definitely shows that it is an incredible force within computer science that, if left unchecked and unregulated, has enormous effects. So was just very happy to see this come up in your paper, and I'd like to thank you for bringing it to our attention again.
It is clear that we're all so impressed that we're into silence. So if it's okay, then I'm going to bring in my own questions, and I'll do that by way of the wrap-up. So I'll not only respond to your position, but I'll try to take upon me the totally impossible task of wrapping up some of the things that have been said. And when we were having coffee, I said that we have been treated to very rich papers, very rich discussions, and it feels a bit like you have this carriage with 8 horses, maybe even 1 trillion, because that's the dimensionality that some people think intelligence starts with, parameters. So we have these 8, let's stick to 8. We have 8 horses and we want to go somewhere because the law has goals. The law has goals. It's not just something that's out there in the air. When governments enact legislation, they have purposes. They want to go somewhere. What is our concern, and that's a concern of the conference, is what these systems do to legal effect and to legal protection. So that is an important goal. Now, so we're trying, we is sort of the conference, we are trying to go with this carriage with, let's say, 8 horses towards that goal. And the goal is how to safeguard, how to reinvent legal protection in the era of computational law, how to achieve it, how to protect it against erosion. And I have the feeling that these 8 horses are all going in different directions and they're all coming from different directions. That might mean that we're standing still or not going anywhere, or the horses might even break loose. So there is the richness is going in maybe too many different directions. Now, is that a problem for this conference? I don't think so. I think it may be very good to calm down, to stand still, and to look where we could go, how we could get there, and what this means. When I look at the different papers, presentations, keynotes, and I'm not going to say anything about my own keynote, I leave that to you, then it would be an interesting question to say, what is the difference between organizing a conference on law and technology, or law and computer science? There is actually an ACM conference now, a computer science conference on computer science and law, and a conference that is about legal technologies, the integration of artificial intelligence, machine learning, and old school artificial intelligence into the law. And that's the focus of this conference. And I can feel that it's very difficult to focus on that. I'm going to be a bit provocative and say that there was only one paper that addressed this. And all the other papers said extremely interesting, rich, important things about law and computer science, about AI, about how they relate to each other, how the one can regulate the other. But there was only one paper that actually addressed, now, what if you actually do legal tech? What happens? What are you confronted with? What assumptions do you have to work with? I'm not even going to say which paper that was because I feel so much like doing a poll to see which paper you think it is. So we'll talk about that over drinks. But it is interesting that it seems it's very easy to have very abstract analysis about the law, but much more difficult to actually go and look, what are these legal texts doing? What are they said to be doing? And what does that mean for the law? Because that is what we want to talk about here. And maybe that's very difficult because very few people are researching that. So there are people building these technologies and they are very enthusiastic and they talk about optimization and about accuracy. And I think Virginia very rightly said, accuracy doesn't mean anything until you know what are the assumptions and what is the precision, for instance. But even accuracy itself has a whole layer of assumptions. If you don't understand them, you might say, oh, that's very accurate, let's do it. But there's no connection. So I'm going to try and see the gold that is lying in the different presentations with regard to legal tech. And then you will definitely find out which paper I think was about computational law. So, and there is space to discuss, to disagree, of course, and to counter-provoke, but that probably has to wait for the drinks because we have another keynote coming. So, Giovanni Sileno, if I understand you well, because my biggest problem is that I often have the feeling then I'm always missing the point, reading the paper, but also when you're explaining it. And I think it's a very important point. I understand that you want to start from these technologies and say, what are they actually doing? What is their actual normative impact? And how does that relate to the law? And then that also brings me back, there is a lot of talk about relational AI, Virginia Dignam. Human rights should be understood in a relational way. You could say legal subjects should be understood in a relational way. Then I totally agree. I think the law is about relational subjects. Legal subjects don't exist in an atomized way. That's just one particular and I think very mistaken understanding of the law. So I completely agree with Sue Ann that that's a very problematic understanding of the law, and people have been writing about why that is problematic for a very long time. A similar conference was organized here in Brussels, where Antoinette Rouvroy, who couldn't make it tomorrow, but her contribution to that conference was about the neoliberal subject and how it impacts mistaken understanding of the law. Anyway, back to Sileno's paper. So you're taking the perspective of technological systems, let's say AI systems, for instance, and say, what is the legal impact of that and how does it relate to the law? My question remains, how does it relate to computational law? I would be very curious about the answer to that question, because that is what the conference is about. So there are many conferences about law and technology, but we want to raise that very specific question. What happens if you use these technologies in the law, to write the law, to make legal decisions that actually have direct or indirect legal effect? So I'm almost tempted to say, let's do the conference again, 2023, and your assignment of all the speakers is write a new paper and now write about computational law. Because it would be quite a challenge, because it also means you have to actually invest a lot of time in exploring what these animals are doing. Then the paper of Denis and Marie, and now I'm giving it away, of course, this is the spoiler, they actually interact with the legal technology. More than that, they're building it. And I think this, because we're talking about computer scientists and social scientists, I think this is what this conference very much is looking for. So that's a combination of an internal critique within computer science, not social scientists or lawyers arguing that AI is all about optimization. Yes, we've heard that narrative now for 10 years. But what do computer scientists who know what optimization is actually mean with that? Why do they think it's a good thing? What are the limits? They probably know exactly what the limits are. To what extent is the incentive structure, the economic incentive structure, the funding incentive structure such that they have to sell their paper as solving all kinds of problems, whereas they are very aware that it's not going to solve any problems, but potentially create lots of new problems. But who is going to pay you for creating new problems? Nobody. Nevertheless, as lawyers, lawyers are trained to be adversarial, to ask the right questions, to say, oh, okay, you're saying your technology does this. Can you explain to me why I should trust that? How does it actually work? What does it actually do? So we invite computer scientists here to this conference to share with us how these systems actually work. And Denis and Marie did that for Catala, and in this case, how to build let me say how I understood it, how to build a decision system based on a regulation, so not legislation, but on the interpretation of the legislation, to make certain calculations that have to be made anyway, and to then at some point come to a conclusion whether doing it by way of this system solves enough problems that makes the fact that you might create sustainable. Yeah? And raising all these questions, who has to make that decision and how can you actually measure that? So you're still talking about upstream decisions taken in the tax authority office and downstream decisions of real people, and that will be much later, and sometimes it's difficult to foresee. But I like this concept of micro decisions that are taken. And that makes it very difficult to make grand statements, like that it works or it doesn't work. No, you have to go in and look and put a little finger behind it and then discuss details. And this is what we want to do. We really need to do that. Virginia talked at a very high level of abstraction, and I agreed with everything she said. The problem is now, what does that mean for computational law? I have only one conclusion. Please don't do it. You're only creating problems, and we in computer science are very aware of that. But okay, if you insist and you want to pay us for it, we're not going to say no. Yeah? So I'm playing advocate's devil, that's clear. So for me, AI is relational, and I would even say it's not just relational, but we need an ecological understanding. So relational is between subjects. Virginia is very aware that these systems are not subjects in the sense that we are. So it's about an ecology in the sense of you have an environment where there's all these technologies that are making decisions. That's already happening, of course, so I totally agree with Giovanni that it's very important to look at it from that side. And how do we help people to use these systems, realizing that these systems at the same time are using them, for instance, to generate data? And how can you then go to the next step and say, okay, how you can interact? So instead of using these systems or being used by them or both, could we come to a moment when you can actually interact with these systems? Because they are trying to foresee you. Huh? We're now talking about data-driven, though even multi-agent systems might have that. To achieve that, these systems will have to model our behavior. And I'm involved in several projects which are called human-centric computing. And that sounds beautiful. Human-centric computing, my God, what more could we want? Human-centric. And then after that, it's all about humans in the loop. But to me, that doesn't sound like human-centric. But when I look what systems are being developed in that context, then we're talking about how to model human behavior. Why? Because we want to do good. We want these systems to understand human beings. And after we've modeled them, we can help human beings to achieve their goals. So before you can actually create this fantastic system, you first have to model human beings. And modeling human beings in terms of computer science means you have to atomize them. And atomize them in the sense of, it was already mentioned several times, in terms of individuals. So you cut them up into different behaviors or attributes. Let's say that you take Two minutes is too little to go into everything else that has been said. But let me say apart from all the provocations that are shared with you, I have really enjoyed the conversation, because you can see that, like these horses, we're all coming from very different directions. We're speaking different languages. We're going in different directions. The easiest way out would be to start talking about shared vocabularies and that sort of thing, so that, after you share your vocabulary, you go back home, you do your own thing. Or you can just say, I'm never going to a conference like that again, and I'll just go home and do my own thing. But it would be better to have these sort of conversations, not every day, but to invest in them. Because if we lawyers do not get to understand what these systems are actually doing, we're going to be in the shit, absolutely. And not only us, because the law, of course, is a public good. It's a constitutive of society. And it cannot be atomized. Okay, now you have my position, and now we're going to go to